let's focus now to the activity that creates the law, that is an activity of the intellect. We will call that activity legal conceptions. Okay. So normally I used to talk about one painting every week. This is the painting for today's class, lecture. Don't you know what is this? I don't know if you have seen that painting, a very famous one, painted 4 centuries ago. Yes, Rodney. Do you want to say something, Rodney? The painter.
The Creation of Adam by Michelangelo.
Very good. Now you're better than the last lecture that I gave 2 days ago. The other class told me, is the image of Nokia. That was so funny. Yeah, but yes, it's Michelangelo. And I don't know if you have seen the whole painting. Well, I will put just to know. He's in the chapel 16. That is very, very, very interesting because, well, the creation. And in which moment? What is the moment of the creation? No? It's precisely before. So, is probably given the soul, probably given the intellect. No? Many people used to say that the creation is the giving of the intellect and the will, giving the soul, the things that only immaterial things have God. So only God can give, because his immaterial can give that kind of thing. The matter cannot give immaterial things. No, the matter can evolve, but not give what the matter has not. So look the form, and it's incredible because it is in the roof. I don't know if you know that it's in a roof of a chapel, the 16th chapel. That is a very big chapel. And there's a lot of things. If you want to know a little more about art, it's good to put here and to see how Michelangelo painted that 4 centuries ago, because he painted not from this side, but from the other sides of the canvas, from the roof. And he put, well, it's a little difficult now. First, normally the last layers of color, so they will fall, and then the previous and the previous and the previous. It's a very complicated technique, and he painted in that way the whole roof of the 16th chapel. This is once again the painting, but and you can see that there are a lot of paintings in that roof. It's not just the only one. It's the famous one at all. But there are beautiful paintings in that roof. And you can see here, more or less, here is the creation of Adam, but then what happened after the creation. So the whole story of the Bible is here and here and here and here and here, in a lot of paintings, beautiful paintings. No? I strongly suggest to check if you want, if you like art, if you enjoy with these kind of things, to check on YouTube. Many of these things are incredible. I just want to be focused.
You could safely say that.
Sorry. Yeah.
The Sistine Chapel ceiling is the single greatest artistic achievement in the Western world. It covers approximately 1,200 square feet, includes 343 figures, and took one man, Michelangelo, 4 years to paint, standing on a scaffold 70 feet in the air. At the center of this work are 9 main panels that recount the book of Genesis. But this panel, entitled The Creation of Adam, is perhaps the most famous. It portrays that very moment when God is about to give life to the first man on earth. Adam is reclined and languid, exerting the barest energy, extending his hand to God. He comes to life fully formed and naked, the most monumental, beautiful male figure in art history. In contrast, God is clothed and floats into the scene enveloped in a billowing red cloak, surrounded by an entourage. God extends his hand as well to Adam. The two hands are so close, and yet they don't quite connect, creating tension and anticipation. Much has been made of the shape of this cloak. Seen in profile, it resembles the human brain. Another hypothesis is that the shape represents the female uterus or womb, and the green scarf is an umbilical cord, which might explain why Adam has a navel, since he was supposed to be created by God and not born. None of these anatomical references would be beyond Michelangelo, as he had a staggering knowledge of anatomy. Protected in the crook of God's arm is Eve, and the other figures, the future progeny of the first man and woman. Between 1980 and 1994, the Sistine Chapel went through a major restoration, removing centuries of pollution and soot from candles. To the dismay of many in the art world, it was revealed that Michelangelo was the most wonderful colorist, and in this humble narrator's opinion, the greatest artist of all time. I'm Larry Withers, and this has been your 2-minute masterpiece.
I know. For me, it's incredible. I know you have heard the story. Michelangelo and the painters of that time used to study a lot with dead bodies to paint that body with every muscle, because they used to paint every muscle of the body. The painters of that time, at night, they used to go to the cemetery and to bury some bodies and to dissect, to cut the skin and to see where is each muscle. So in that way, they were able to understand where is that muscle, to paint that each muscle. So if you put a lot of zoom there, you are so close to the photo of the body, you will realize this is that muscle, this is that muscle, this is that muscle. It's incredible. I really think that is a marvelous painting, no? But the most interesting thing that here that I wanted to put that is that is for centuries the belief that the most important thing that differentiates us from animals is or at the level, at the biological level, is our brain. That is quite different from the other species. But the deepest thing that differentiates, not biologically, but absolutely, is our soul. No? Our intellect, our will, both, because the will is just the appetite of the intellect. So we can understand abstract knowledge. We are responsible. Animals are not ethically responsible, legally responsible. They have no liability, nor a river, less a rock. Well, so that is the thing, no? And we will talk about that, no? Specifically, our understandings. Our understandings, in this case, not of everything, that is the theory of knowledge, and we are on jurisprudence, but our understandings of the law. And to that understandings of the law, we will call legal conceptions. So what is a legal conception? This is easy. A legal conception is our understandings of the law. But let's be a little deeper. Now, let's try to put a little effort and to define it technically. Technical legal conceptions, let's go little by little. Technically, legal conceptions are the result of the judgment of practical reason. What it means? What it means? No, it's a judgment. It's a judgment. It's a judgment of the intellect that says this is just or this is not unjust. This is according to the law or this is against the law. So this is legal or illegal, but it's a judge, no? A judge. Something is another thing. This is legal, this is not. That is why it's a result, a conclusion of a judgment of practical reason. So what is practical reason? Perhaps you could know in another subject that there are two kinds of reason: theoretical reason and practical reason. The theoretical reason is the things that normally scientists used to have. For example, or any people know that tree is green. Tree is green. Two notions connected by is, but the verb being. That lake is big. There are so many ducks. Yeah, but it's just theoretically, no? Yeah, we understand a little better reality when we got many judgments of reality. No? This is this, this is this, this is this, and we can connect judgments and create some more complex ways of reasoning. This is more or less how it works, the theoretical reason. But the practical reason is a judgment, but related to the things that we should do, to the things it's good to do. For example, to drink water, no, because I have to survive. That is a judgment. No? It is good to drink water, and it's even better to eat chocolate, and even better to eat cuckoo or whatever you want, ugali, whatever you want. So that is quite interesting. Because a practical reason is something that relates with something that should be done. Obviously, there are things that should be done by reason of ethics. That kind of things we are not interested here. Principally, we are interested in those things that should be done for the sake of the law, by legal reasons. So that is the thing that we will add. No? Legal conceptions is the result of the judgment of practical reason, which, taking into account the being of the scenes, the legal notions and values, principles, and norms, all the things that we saw last week, prominently determines what is due in justice or what is the right. So it's the same thing that we said, but now with a lot of precision. Is why we say that you should do that. Well, because we have some principles in our mind, some values, some ends for our society, for our projects, some notions, previous notions. So that is quite important. No? It's a judgment, but based first on reality, second on the ideas that we have in our head, notions, ends, values, principles, the things that we know that someone decides, authority, norms, according to everything, we can say you should pay because, well, there is an agreement and pacta sunt servanda and so many things. Huh? So, any question? Did you understand more or less well what is a legal conception? Well, if there is no questions, let's go ahead. This is the example. No? We understand nature. So we realize nature is so beautiful, it's not good to destroy. There's some animals in danger. Well, so let's protect them. Pro-nature, pro-nature. And that will create the environmental law. Environmental law, a lot of protection of animals and many things. And finally, we'll realize that everyone has the right to ask for the protection of nature and things. No? Is able to ask that right. So any human being, each one has the right to an air without pollution, to the protection of the endangered species, and so on. Okay, so that is the notion of legal conception. Second idea here. Well, there are three questions that will be the creation, the transmission, and the cessation of legal conceptions. How they appear, a legal conceptions. How they can be transmitted to another person. And finally, the cessation of legal conceptions. So, what do you think? How a legal conception can be created? When is the first moment where a legal conception appears in the face of the earth? The first moment, the apparition of a new legal conception. For example, a tradition. For example, an understanding that something is to be done, should be done. Normally, when I ask this, many people struggle to give an answer. But if I ask another question, it will be easier for you. That is very important here. No, I will say it's more important. Try to think about that. It's good to talk also because in this way you will realize you will try to put with precision your knowledge than to memorize. First, because you will need more memory, and second, you can memorize everything without understanding. And everything here you can get just by reason, by deduction. So I will repeat the same question with different words. When ideas appear in our mind, when is the beginning of an idea, how they are created in our head? Because a legal conception at the end of the day is a set of ideas related to the law. It's a judgment of the practical reason. That is an idea. So how ideas appears in our mind? Anyone wants to try? How an idea can appear in our mind? What do you think? Well, I will say There are many ways an idea can appear when we are searching for the solution of an issue. Perfect, we need perfect. So that is called one word: meditation, reflection, yeah, thinking. When we think, we're trying, yeah, perfect, trying. What is the answer to that? And at one point, we realize, whoa, that is the best way to do that, and that is the solution of that issue. Perfect, exactly. Any other possibility? That is one. That is one, by reflection. By reflection. No one. So let's put the examples. Well, by evidence. By evidence. How do you know that, for example, outside of your home there is a tree? There is a tree. By evidence of your eyes, of your senses. It's evident. Yeah, I just go open the door. In front of me, there is a big tree with a lot of flowers, or I don't know, by evidence. But here is different. It's not just a simple idea that appears here. There is a tree there. No, no. A legal conception is a legal idea. Legal idea. So should be related to what is just or what is unjust. So by the evidence of fairness, that is the idea. It's not just the evidence as any idea, well, that is evidence, it's obvious, but the evidence of fairness. And there are many things that we know by evidence. For example, pacta sunt servanda. You should fulfill your agreements, your pacts, your contracts. If you told me I will do that, I will expect that you will do that. Yeah, pacta sunt servanda. And why? Well, many times it's difficult to explain evident things. And I will say, because you told me. The same reason, because that is evident. You told me, so I'm expecting that you fulfill your word, that you should do the things that you told me. And why? Probably you will repeat the same, no? Because everyone should fulfill what they say that they will do. So it's evident. But as this, there could be many other things. For example, neminem non laudere, another phrase, another idiom in Latin. Nobody should harm the other. Yeah, because the other has dignity, and we have to respect them and so on. But it seems a little evident for everyone. Probably there could be some cases of exception. No? The legitimate defense, for example, we will see next semester the requirements of the legitimate defense. But as a general rule, there. And that is very interesting, no? To know that there are many things, that phrases, little phrases, idioms, it's called in many, you can call that in many ways. Brocades, aphorisms, dictums, but at the end of the day are phrases said by a genius, normally very great jurist in the history, that many people used to repeat, because all people realize that there is some evident truth. That's pacta sunt servanda, neminem non laudere, in dubio pro reo. It's another that people used to repeat. And you can find that not only in one culture, but in every culture in the world, will say that you have to fulfill your agreements. You cannot be a traitor. You cannot be a traitor. That is everywhere in the world, and not just in this generation. I mean, 2,000 years ago, everyone in the world realized the same things. And if every one of the humankind of any time agrees with something, probably it's because that is evident. And that is probably the first layer of the legal knowledge, the evident, the first layer. So that is quite important. Second, by reflection on what is just. Yeah, we don't know very well, as Renee said, well, we're struggling, we are searching what could be their solution in this case, who has the right, the woman or the man. And so at one point we realize, no, someone, the woman or the man, I don't know. I don't know what case, but after some reflection, we realize what is just. Third one, by experience. By experience. By experience, we know many things, no? Normally, when we are very young, a child, our parents told us many things, well, with a little kind of punishment. For example, if we are trying to put our hands in the fire, and we are very, very young, and we don't understand very well what is fire and what kind of things, probably we will receive a slap of our mother saying, don't do that. Well, we don't understand why we will do that. And when there is no, when our mother is going away, we will try to put the hand on the fire. And then we will see why is our mother slapped our hand, because, well, it's not so good, because we will feel so bad. By experience, we will learn that the things that our parents said, told us, have some reason. Probably when we have 5 years, we didn't understand the reasons. By experience, we will know that was not so good. The same happened with the law. Exactly the same happened with the law. Remember, here are legal ideas, legal conceptions. No? So it's not enough the experience, but it should be the experience of what is fair or unfair, just or unjust. I will put now a second example. No? I have a friend that was a terrorist. A terrorist. Is a woman, by the way, in my country, and was incredible because after one act of terrorism, she was imprisoned for 3 years. 3 years. She suffered a lot. At what point she realized that she should change her life. So in the middle of that strong experience of the prison, he realized that, well, that is not good. This is not good. No? There are people that can suffer the same things and will be worse. No? But probably if you have a good heart, you will change for good. A strong experience, if you have good heart, you will change for good. If you have a bad heart, if you hate someone, probably it will be worse. If you hate, strong experience will increase your hate. But if you have a good heart, marvelous things will happen. So by experience, we understand, well, the same phrase that Oliver Holmes used. You remember, no? What is the law? But a bad guy understand by experience what is the law. Well, now we are applying in a systematical way, Holmes, by experience. But you should know that is not experience alone. Should be experience mixed by a certain reflection. No, I did that, so and I'm feeling bad, so probably it's not good for me and for anyone. So it's an experience mixed by reflection. Another one, by intuition about what the law could or should be. By intuition. And intuition is a very difficult word, a very difficult notion on philosophy of knowledge. There are many understandings of what is intuition. But at least we have a little intuition of what is intuition. A preliminary notion. I think that we think more or less that it could be in some way, but we cannot explain very well. That is more or less an intuition. And many times we have that. We have not the conclusion strictly by reflection, a very systematic reflection. This, the conclusion is that is just and this is unjust. No. Many times we understand, well, probably this action is not good to do. Well, many times our conscious or our inconscious give us some notion of what we should do. And it's good. Try to clarify those intuitions. But many times we don't have a clear conclusion, but just an intuition. And finally, by human creativity. That is also interesting. No, it's not an intuition, but no, it's a creativity. No, think about the imagination of the legislator. That someday they realize, well, it's good to create a fiction, and they create a fiction. But first, the fiction was in their heads. Another example, traditions. There are many traditions, beautiful traditions. For example, here I saw that many trees are considered sacred. And obviously, with a sacred tree, you cannot do many things, no? People used to bury the sibling, the family there, because that is a sacred tree. So there is a lot of rules related to sacred trees. Well, obviously, you can believe or not believe, but at the end of the day is to some extent, and from some point of view, a creation of human intellect, no? A creation. In another culture will be a cow. No, cow is sacred. No, well, so we can create with our mind many things. No? Obviously, there could be also the creation of God. That is another possibility. No, but many times in many traditions, there is a creation of a community. At one point, they realize not that should be in that way, and they will explain why. But once again, is a reflection of the practical reason that understand that this is just or not. But it's a reflection and justified in some kind of arguments. Okay. Any question here? Now, after seeing the creation, we can see the transmission of legal conceptions. How they can be transmitted? Well, a transmission implies two people at least, the issuer and the receiver, the one who has first the legal conception, the idea, and the other that will receive the idea. So how can be transmitted? How can be transmitted a legal conception? Anyone wants to try? How can be transmitted? Let's put in this word the same question. When do you realize what is the law? When do you know what is the law? Yes, Renee.
When it is codified and you can read it from a document.
Perfect, very good. When you can read it, that is an act of communication. Yeah, you can read in the newspaper, any other possibility. Yeah, but this is an act of communication. Can be written, or can be your parents. Today, your parent appears in your at home, and they said, "Don't you know you cannot go outside because there is a curfew and it's 5 o'clock, the new curfews," and you will believe in them. Probably they heard that news in the newspaper or in the television or the radio or by another friend, and the same and so on. But these are communication. Yeah. Another possibility. Yeah, but it's more or less, I think that you understand. Let's go to the technicalities now. Because who receive the legal measures agree with it. And by faith in some authority that indicates what is just, and by act of a simple trust that the receiver gives to the interlocutor, and by the simple acceptance, conscious of what is. I will give you a minute and try to differentiate these 4 different cases. Try to think alone. So I will give you a minute to read and try to understand this. And let's see if you are able. If not, I will explain the word. Perfect. So, did you see the difference in these 4 cases? Any one of you want to distinguish at least 2? I think that is interesting to see. I know there could be a little tricky cases, but okay, so don't worry. So think about this. If your parent one day appears in your home and say something, well, it's quite different that if you read the official publisher of the law and you realize there is a new law, well, because you are in the original source of the law. If you read the official publisher of the law, in each country is different. So could be a bulletin, could be a kind of newspaper or whatever you want. Well, you will be in the original source, no? Of the authority. Or if you hear from the same authority appears on television saying, today the curfew will be at 5 o'clock. Nobody can be outside walking on the street from 5 o'clock of the afternoon to 5 o'clock a.m. Okay, so you believe in one authority, and that is faith. That is faith. That is interesting. That is faith, but obviously not in God, but in the authority. It's a strong power that the authority has to change the understandings of a whole society just with one word. They say, today the rule is that one, and the next day everyone will believe that the rule is that. It's incredible. It's a very powerful power over the minds of the whole society. From time to time, society will say, no, that is not the law, and they will be very convinced. And many times the authorities will say something, the society will do exactly the contrary. That in many cases around the world, in every country, because the society will say, no, that is not my law. I don't agree with that. If the whole society said that, there is no new rule. The authority was not able to convince society, but faith in some authority. But quite different was the case of the curfew with your parents, no? By a simple act of trust in your parents. Normally we trust in the people that love us, or parents, no? Trust. So probably I don't know. I think that my parents have no reason to cheat me. They will not try to convince me about evil things and to convince me about every lie. No, they love me, so probably they are saying, well, I will give a simple trust to and I will believe that that is the law from now to I don't know when, because they told me that that is the law. Many times traditions works in that way. We trust, we give a simple trust to the people that loves us. That's why we believe that is the law. We heard that from the very beginning of our lives, that we have a strong belief. It's a simple trust. The first case, because who received the legal message agree with it, is a little different. No? Probably, I don't know, is the case now in the university. There are many things that you hear in your classroom. And there are many things that you will say, I have some doubts. But normally, most of the things that you hear on the university of what is the law, you will agree. Normally, yeah, for example, if I tell you for the first time the idea of pacta sunt servanda, and you never reflected on that in the past, you will agree, well, it seems to be logic, no? If you gave to someone your word, you should obey, you should fulfill the thing that you told that you should do. I'm telling for the first time, but you understand that, well, it's logic. The professor is not telling something new. You will feel, no, what's new here? No, what the first time, but this logic. No, so I'm transmitting you a knowledge, but you, by your own resources, you will discover the truth that is behind those words. Can you see the difference? Can you see between the first, the second, and the third? Okay. Now, the most difficult one. Yes, Renee, you raised your hand.
Yes, I have a question.
Perfect.
In the third instance, when you say simple trust that the receiver gives to the interlocutor, who exactly is the interlocutor? Is it the legislature, the people who create the laws, or who exactly is that party?
Yeah, perfect. Good question. If there is an authority, is trust or faith is more or less similar. Okay, if it is the legislator, is the second case. If it is someone that is not the legislator, is the third case, or the authority. Okay, could be, for example, many times it's just a journalist. The journalist is not the legislator, but the journalist says, no, from yesterday was approved this law, and you're believing in that person. I mean, it's not the authority. It's not the authority, but you will say, normally they used to say the truth, so I will give a simple trust. Can you see the difference?
Yes, I do. But I have a follow-up question. So does that mean that in the third instance, anyone can be a transmitter of the law, or rather,
yeah, absolutely.
Legal concepts?
Absolutely, absolutely, anyone. And normally is we receive what is the law by anyone. Sometimes by the legislator, sometimes we read the Constitution, but normally we hear in some conversation now was approved, and we will keep that idea in our mind, and that will be the law for our community of friends and so on. Yes, anyone. Yeah, obviously they will ask to trust, some kind of trust based, and I know that the legislator did that, but many times they didn't. They didn't. Many times, for example, I will put an easy example. In everywhere in the world, many times, one is the act, the statute, or even the constitution approved by the legislator. This is the text of the constitution approved by the legislator, and the official publisher will change some words, some commas, some points will change. Many times a deep change, no, not little ones, deep, very big change, no? And they will publish this. And what will be in the constitution approved? That one that everyone read. Published by the official publisher, not the one that was approved by the legislator. It's incredible. It's the very big power to convince people that that is the constitution. And that was not approved. Can you see? That can be anyone, and can change the law if you put tricky things. Let's go to the last example. By simple acceptance, conscious or unconscious, of what is seen in others, traditions, practices, custom, etc. So that is quite interesting. I remember always hear Alf Ross. I told you when we saw the historical part of the authors, every author, if they are successful, is because they got some part of the truth. Alf Ross, the table of chess, that play. How do you know the law? Well, seeing how the players used to move the bishop, the queen, the king, you realize, that is the law, just seeing everyone here. No? If you see this movement, for example, from if you are from a Canva, no? That everyone is getting married with the 5 visits to the family of the bridge room. So 5 visits, and from very child you just see, no, conscious on your conscious, and after seeing that for 20 years, you will know how to marry. How? Well, in the same way that you saw for many times during your life, and you accept, more this is accepted, conscious or unconscious. Yeah, probably you will. It's not a reflection. No, I should do that because that. Yeah, conclusion. No. It's just I accept the things that I see in my society because seems to me not bad, and even there are some good things there, you know. So traditions many times is just by conscious or unconscious acceptance, because you see the same thing everywhere. I mean, in your community, and that should be the law. That should be the law. Can you see the difference in this case? Nobody is telling you this should be done. It's not authority. It's not someone that is giving you a legal message. You're just checking, you know, how the players of your community used to play the law. We will say here. Alf Ross was brilliant, but obviously incomplete, but was brilliant. I really agree with him. Incomplete, and here I think that you can find the part of the truth that he found. Okay. If there is no question about the last case, we can go to the cessation of the legal conceptions. How legal conceptions finish? Or the same question, how our ideas finish? We don't have, no longer have the same ideas in our mind. Can you imagine? Can you? I will say this is one. By a legal act that is contrary and sufficient to change the legal conception. We know that there is a curfew and we cannot go by car at midnight because there is a lot of measures, lockdowns. Now fortunately, but things are changing. No? 1 week ago, or even 2 weeks ago, I think that there was so high the peak of coronavirus cases. No? But now in this week, fortunately, changed things, and we are less than 5%, I think so. So once again, there is no need for lockdown. No? And the authority changed indeed the measures, no? The measures. So we can do many other things today. 2 weeks ago it was a little different because there was a peak. So if the authority changed a legal act, activity, that was contrary to the previous one, what will do? Everyone will realize, will understand that the previous measures have no force today. So a legal act that changes the mentality of one society is enough to change and for the cessation of the previous conception of the law, but should be sufficient. Second, by generalized substitution with another legal conception. That is interesting. No, many times it's not the authority. The first case is the authority. The second case probably could be your community. No? One day the elders meet somewhere and decide, no, these kind of things probably is going. We can allow to do the same things, but in many other ways. No? To get married, not just with this ceremony, but also by the procedure approved by the state, the elders of your community. So everyone will have two possibilities. Huh? So this is a little change. This was indeed a little or a big change because the new now we are in a country where we are in Kenya. We are free to some extent. We have to conquer freedom every day of our lives, everyone. But to some extent, some kind of political freedom. So we have many possibilities. Well, yeah, little by little, our understandings of what should be done legally are changing. No, that is interesting. But should be generalized. It's a generalized substitution. It's not just one crazy guy that thinks, no, the thing should be done absolutely contrary. No, it should be the whole community or the whole parties if this is an agreement. By general forgetfulness of the legal conceptions. No, sorry, this is general forgetfulness. What is general forgetfulness? Well, we forget. We forget. It is incredible. Many times the legislator never will say no. If you forget what is the law, there is no longer in force. But that happens. That happens everywhere. I remember one incredible statute in my country that centuries ago approved one way of doing some recipe, made some specific food, a recipe. There was a law. Imagine that. Obviously nobody fulfilled that at that time. Well, some of them yes, but people forget immediately. And so now there is no people that understand, that know that that law was never changed. It's technically enforced, but nobody knows that. So if there is a general forgetfulness of a law, approve it, not change it, well, there is no longer that law. Nobody can ask you to fulfill that. Countries with a long tradition of having their own laws, normally they realize that there are laws that everyone forgot. So are not longer enforced. Well, perfect. That is the three things: no? The creation, the transmission, how they finish legal conceptions. Now we can talk about the types of legal conceptions, but I think that is good to have the breakdown, if you agree, obviously. I don't know if you agree. In any case, we will have 10 minutes of break. Let's see you, or 12. Let's see you 10:20. Perfect. So we can continue with the legal conceptions. Now we will see the classification of legal conceptions. How many classifications could be? Well, probably infinite numbers of classifications. So I will use just 4 criteria to classify legal conceptions. First, according to the necessity, natural and cultural conceptions. According to the subject, legal conceptions of one guy, individual conceptions, a group of people, or many, the whole community. No? That is according to the subject. According to the written law, well, there are many conceptions created just reading the law. Many people will read the law and will give one kind of interpretation, other kind of interpretation, so are based on the law, no? So or not. So this is another criterion to classify legal conceptions. And finally, there are true and false conceptions. So what it means is this, no? That are conceptions that are according to reality and others against reality. We will see today just 1, 2, and 4. So let's go with the first one, natural and cultural conceptions. What is about? No, well, we say something. Natural legal conception is a set of legal conclusions that are necessarily obtained by known reality and by correct reasoning. This is you have everything in the code. It's so important to do all quizzes, to read the code, by the way, in this part. In the previous part, in the historical part, there was a book. For this part is the code. You have more or less the same, but with a lot of details you will realize when you read the code, the reading for this book. So remember, every legal conception is a conclusions of the practical reason. In easy words, is what we understand that is just. Yeah, but our understandings can be related to we saw, no? How our understandings of what is just, what is the law, are created, well, in a necessary way by evidence, for example. No? Well, if you have evidence, intellectual evidence, that you should fulfill your words, your oath, your agreement, that is evident, no? So it's necessary. You should conclude that. And normally there are many things that everywhere in the world, in any culture, that was Malinowski, that was Max Gluckman in Johannesburg, you will remember. That was Montesquieu in France, time ago. There are something that everyone is sharing, probably because it's evident. It's evident. And that's why the conclusion is a necessary conclusion. It's a conclusion obtained necessarily by knowing the reality or by the correct reason. By knowing the reality, no? I'm selling you a computer, I cannot give you a rabbit, no, because this is not a computer, no? And the agreement was about a computer, not about an animal, a rabbit. No? So knowing reality and a correct reason, you should fulfill your oaths, agreements, words. Okay, so that is the natural. And we saw also that the necessary reasoning, the evident understandings of the law is the first layer. Don't you remember? And that's why, because it's the first layer of the ring of the wood. You will remember the first slide of every lecture in jurisprudence is a wood cut in the middle. You can see the rings and you can see it. So which is the first layer that we have about the law in our knowledge? Well, precisely this, no? The necessary reason, no? The most evident knowledge of the law. So all legal knowledge should be built on this knowledge. The next layer of the tree, the next rings of the tree will be over the first one, So and if the first one is break, all of the others will have a problem, as you can see. Okay, so what includes the natural legal conceptions? So let me see. I have a question. Do natural conceptions in any way give rise to natural law, or is the origin of natural limited to human nature? A very big, and deep and good question. So the answer is depend of what do you understand as natural law, because there are many things, no? But I will say that natural law is principally a conception. It's not written, no? It's not written. It's not written anywhere. No? You can write something that is I mentioned what is natural law. For me, at the end of the day, is something that is reasonable in the law. Reasonable in the law. You understand that you have your right to life, not because someone approved in the parliament, no, because, and you will say, because this and this and this. That is a reason. You are giving reasons, argument, rational argumentation to support that right. So what is natural law at the end of the day? A legal conception. But there are many legal conceptions. No? One created by necessity. I will say natural law. Yes. So my answer for you, Renee, is yes. Okay. But I explained why. If you have another understanding of what is natural law, probably you have to put some difference. Okay. So what kind of things the natural legal conceptions include? First, the direct knowledge of reality. No? To sell a computer, I should know at least what is a computer. So I will put a price depending on the value, the objective value, and the value for myself, and the value in the market, taking into account these three kind of things. But because I know the reality of the computer, of myself and my situation, and the reality of the market, I know I can put some value, no? But I need first to understand a little reality, no? And then I will, that is why that is the first layer of the legal system, of the law. If we don't know that, we cannot build anything. We cannot construct any argument. Then the necessary reason. The necessary reason. There are things that you should conclude immediately. No? If you told me that you will sell the computer and I'm paying the money that you asked for, well, you should give me the computer. What? You told me. The answer is, you told me, please give me your computer. I already paid. Why? So the answer is evident. Will be the same answer because that answer is a necessary conclusion. A necessary conclusion. So everyone in the whole world will say, obviously, if there is some problem because I have to fix the computer and I will give you another new one, well, that is different. No? But normally, you understand very well that there is a reason that if I pay, you should give me what I paid. Third, the basic conception of thought. That is a little more than the direct knowledge of reality. It includes a little reflection. Remember, not for a creation of a legal conception, you have to reflect, not trying to find some answers. No? So it is not enough to know that there is a computer, there is a market, there is a lake, there is a tree, there is a dog. No. We should know a little, we have to give some value of each one. No? And we will realize, first idea that is so important in the legal system. If you don't have that idea, you cannot work in any kind with the law. It's impossible, the law, to distinguish a person from things. No? Person is a subject of rights, and things is an object of the legal relationship. So there is no legal relationship without two or more individuals considered as a subject, center of rights, duties, expectation, legal expectations, I mean, and so. And a thing that you can relate to, no? The thing can be material, could be work, could be a computer. So you have to distinguish this, and this is a little reflection, no? A little basic conception of their life. If there is no person, well, there is no law, because a person is the one you can give one right or one duty. So and many other things, no? Many other things. What at the end of the day, also, what is the human life for? No? So a basic conception is you need to understand the law first, no? To understand what is the legal system for. Little by little, well, you will realize that that is the first layer of the legal system. No? Fourth, knowledge obtained by evidence, also, not by evidence. There will be many other things. But obtained by evidence. No? But necessary. What is evidence? A necessary conclusion, because the sense we understand by the evidence of our sense, or by the evidence of our knowledge. And intellect, evidence is this one. And finally, by extension, well, the notion, ends, principles, rules accommodated to the human nature in the previous ways. For example, if I understand that one of my ends, goals, aims is nutrition, because I have a mouth and I feel I'm hungry, a little peckish today. So I understand that, well, I need that, and probably according to the dignity, I cannot die because I don't have food, and so there should be a right, and so it's a little reflection that will get an end based on what? Well, on direct knowledge of reality, the necessary reasoning, the basic conceptions of thought, by evidence. So I will, by these 4 ways, methods, I will get some notions, some ends, some principles, some rules also, and all of them will be a natural legal conception, or if you want to use the word natural law, that will be the natural law, the most essential part of natural law, at least. Okay. On the other hand, what is a cultural legal conception? A cultural legal conception is that legal knowledge that is not unnatural. It's easy. that legal knowledge that is neither evident nor necessary that each one has about the law. Yeah, it's dependent on our culture, the things that were approved in the parliament. That is not necessary. Many laws can be in one way or another. In which place you drive, no? Well, in some countries it's at the right, and the others at the left. At the left, so here is at the left. In my country is at the right. Well, you can choose. You can choose. So everyone understand that is here or that, but it is not necessary. Not everyone should be in this way. No? Okay. So let's go ahead a little more with the cultural conceptions. Cultural conceptions are formed by, and he will remember another author that we saw in the historical part. So first, the intellect, and the intellect capture the evidence necessary law. Well, it creates a unnecessary. But when he reflects a little more, when there are many options, well, we have culture when it does not get reality work. Second, by the will. That is interesting. I want to stop here a little. You have everything with a lot of detail in the code, but I want to stop here a little because that could be interesting. The will. Why? A legal conception is a conception of our intellect, not an activity of the will. Yes. But what happened? That sometimes the will force the intellect to opt to some kind of knowledge, to some kind of understanding, for good or for bad. So I will put two examples. If there are many options, for example, the intellect says, well, you are the judge, you can put the judgment 2, 3, or 4 years of prison as a punishment to that crime. And you decide by the will, no? 1, 2, 3, or 4. Well, the will is forcing more or less the intellect to choose one option, and from that moment, that will be the understanding. Is 3 years, for example, no? Accepts or rejects the evident or necessary law. Second, to choose a possibility, more or less the same case. And the third case is the most interesting one. Many times, when we don't want to do things, when normally the will force the intellect to understand some specific thing. Let me explain with one example. Two examples, one not legal and the second will be a legal one. At 10 years, when you're 10 years old, everyone I mean, normally people understand very well things about sexuality, what is good, what is not good. Many times in the high school, many people realize, well, there is pornography, there is many other things, and they began to check these kind of things, and the intellect at the very beginning used to say, no, your parents told that it was not so good, but many other things, and you realize, no, but it's so incredible, and the will try to say, well, think about that again. Probably no, the thing that you previously know should be in another way. So give me another option. The will ask to the intellect another option. And little by little, the intellect will justify that activity. And in that way, the people that used to do bad things, they used to excuse themselves. The bad things that they understand that are bad things. I'm not talking about any objective law. It's the way of the people used to proceed. Another example. As you, I was one day in the university hearing my professors with a lot of friends. I really appreciate today, till now, all of them. But unfortunately, many of them are not so honest. Some of them, unfortunately. I really appreciate all of them because they were and they are good friends. Even there was a good friend that was had a very bad life and is in prison today because of that. What is the process of many of them? No? At the very beginning of the career, they realize, no, we should fight against corruption and many other things. But at the beginning of the career, there begins the little corruptions, and the intellect will say, no, you cannot do that. Then they will, no, but think twice, because you need the money, and because everyone is doing this well, and the will with a second option to the intellect, and there is a tension. People used to feel that they are in tension, especially at the beginning of the career. But if you accept 1, 2, 3, there will be no tension. There will the conscience, the intellect will be relaxed, and they will do whatever. And at the end of the day, the same people will admit, no, but I have to do that. I have to do that because, and there will be whatever reason that you want. No, today you see in your politicians, no. No, the other day I heard that reason. This politician is robbing, but not it's because he's a corrupt. It's because he wants to be president. He's just taking money for one purpose, and that justifies everything. Obviously, it don't justify, but it's a way that the will can force. So it's good to know that the will can influence and have a lot of influence in our intellect. And that is why it's so important. Try to be honest. If you understand that something you should do or you shouldn't, or you have at least an intuition, try to respect your conscience. And if you try to respect your conscience, you will be your whole life honest. But let's try to do that. No? And if you put excuses today, I assure that you will be a corrupt. 10 years, no more than 10 years. No? You will be a corrupt if you put excuses to your actions. No? Okay, so let's go. Finally, the psyche, our psychology can influence so much. We will remember here Frank Giron. We will remember here Jack Lacan and many others that talk about the conscious and unconscious plays a role in the law. They didn't explain very well how. Here I'm trying to explain a little more. Well, how the psychology can have a kind of influence? Well, precisely when the intellect is judging what is just and what is unjust. Well, and if we feel so bad against something, we will consider that to achieve that value aim will be illegal, no? And you can have good or bad results. It doesn't matter. Here I'm just explaining that the psychological issues or characters, personalities can have a specific influence of what is the law. Okay. I don't know. Well, the formations also depends on the circumstances of play, history, physical and mental factors. Normally people that are in the coast are more open more open to forget, for example, and the people that lives in the mountains. I'm very high, not like in Nairobi. In my country, it was that with a lot of cold, normally they are not so open to others, and well, because it's too cold, too cold. Yeah, so normally they are separated as well as in the north of Europe. So and you will see that the laws are so different everywhere. So that is natural and cultural conceptions. Now, according to the subjects, could be the culture and tradition as a source of law. The traditions, once again, the thing that we have from the previous generation, a tradition. No? The common opinion, that is quite interesting. The common opinion, what is the common opinion? Well, the opinion of everyone that is common. It's so easy. But who is everyone here? That is interesting. Who is everyone? Not everyone in the world. Not everyone in Africa. No, it's everyone in the specific legal relationship. So normally I ask here, what do you think about this case? I'm selling you my car. I don't have car here. Well, suppose that. I'm selling you my car, and I think that is in good conditions. I sell the car to you to, for example, $3,000. And you buy in good faith that car also, as well as myself. I'm selling in good faith, and you pay that. And after a week, you realize that there is a problem. The engine has a problem that should be fixed and will cost $1,000. Well, it's a lot, but I sold that in good faith. Normally, everywhere in the world, well, it depends, there is a lot of things, no? But normally, if both parties were in error and the error is not substantial, that there is a lot of precision in the words, the agreement is valid. So yeah, but it's quite different, this example, because there was a common error, an opinion and that is valid, a common error, a common opinion of what was. It's quite different if I know that the car has a very big issue in the motor, and I'm selling, and I never tell you that the car had that problem, because that is fraud. I'm cheating you, and the agreement is not valid. You can go everywhere in the world to the judiciary asking for the declaration of nullity of that agreement because it was created by fraud. Can you see the difference? In the second case, there is no common opinion. So in this case, in the first case, there's a common error, because the opinion was the same. So the common opinion can create the law. Can you see? Even the false common opinion, not only the that are according to the truth. Third source, no? The doctrine of academics as a source of law. Someday you will be a lawyer. Someday you will defend a client. Someday you will appear on courts. And you will show, no, that is the law, that is the evidence, and the other party will say, the counterpart will say exactly the contrary. No, that's false. The law is this one. So let's prove what is the law. So what do you have to do? Well, obviously to check the written provisions of the statutes, of the constitutions, of the treaties, But also try to check if some author mention or give some interpretation to the Constitution. And if you find 10 authors that say the same, you will put the same 10 authors. No? And the other party, if they say, well, no, that is the law, well, what they have to do, try to find another author that have a different opinion. And if the other have no different opinion, you will win. You will win. I also exercised the profession in a country that was with a lot of corruption. At one point was in the top 10 in my country, or very close, the most corrupt countries. And I will say that this is a strong evidence of what is the law. Normally, even in those countries, if you show that 10 authors say that that is the law, the judge realize that they cannot say a different thing, even in the most corrupt countries in the world. So that is good to know. You can exercise honestly the profession also if you have a lot of doctrine, you show what is the law. Because it is a strong argument, and the author will realize if I say the contrary, the judge will, well, someone will check, and I cannot go ahead in my career as a in the judiciary, you know. Well, so just an example of what is happening. So the doctrine of academics is absolutely a source of law. It's just understandings, ideas. But if everyone shares the same idea, well, obviously, many times it's not possible to that everyone's agreeing. There always will be a crazy guy that has a different opinion. On international courts, that is quite interesting. You have to prove the law. Here in Kenya, no. If you're going to a judge, normally judge from Kenya knows what is the law of Kenya. You only have to provide evidence and your arguments, no? But you don't have to prove the law. Quite different is on international courts. If there is a case, for example, in the International Criminal Court or in any human rights court, obviously, against one country, against, for example, Uganda, it's obvious that the judges of that case cannot be from Uganda. So there should be a foreign author, a judge. And if they are from abroad, what will happen? They will not know what is the law. Simply, no. It's so simple. So you have to prove the law. And in what way normally they used to do that? Showing experts, bringing up experts. I was an expert in Atlanta time ago in a very big case, probably the biggest case of Ecuador that they had, explaining what was the law in my country. No? And because, well, they believe in experts, and what will do the other party precisely present different experts that have a different opinion, because if not, they will lose the case. So you can see, and if every one of the experts, not of the crazy guys, no, of the middle professors, no, the common and constant doctrine of expertise is according in one point of the law, that is the law, that is the law, that is the law, and that is so clear in international courts of human rights, of criminal law, of whatever you want, trade law, whatever you want. So these are according to the subjects. No? If you have any question, you can stop me or ask in the chat or raise your hand, whatever you want. No? So we said already that based on not in written text law legal conceptions. We will talk about that next week. The fourth and last classification of legal conceptions are true and false conceptions. There are some that is according to the truth. Obviously, yeah, if I say that you are the owner of, I don't know, the computer that you have in front of you, probably it will be a true legal conception, an idea that I have, that is according to the truth. Probably, I don't know. In some cases, the computer that you have in front of you is not yours; it's from your parents. Well, so I will have a false conception. What is interesting is that both are able more or less to produce the law. That is what we will see. The true conceptions is easier. But what about the erroneous legal conception? That seems not to be so easy. When a legal conception can produce the law, when an error, an authentic error can produce the law. Well, we have to find the error, and if we don't find the error, well, that can produce the law. That can produce legal effects, and how? That is the question that we will deal now with that question. Let's put an example. First example, it's an easy example. Fishing. Fishing is a crime. Fishing is try to find the password, the login names of other people, the numbers of credit cards or debit cards, whatever you want, and use them in another page. And you will show in some place in Amazon with another name, another guy, and with the credentials, credit cards, numbers, passwords of another. Obviously, for your own sake, not for buy something. I suffered time ago that someone found my credit card number, bought a computer, and computer was in another country. So, what do you think? What should happen with that? Obviously, Amazon was cheated. Amazon believed in good faith that the one that was buying the computer was myself. And he wasn't, obviously. That error can produce the law. We are talking about errors, things that we understand and are not according to the reality. That error can produce legal effects. What kind of legal effects? If you suffer, if you're in my position, what you will do? I will tell you what I did. No, I immediately, if I was able to do that, I will put a denounce in the judiciary because that is a crime. That is he stole my money. But he was in another country and it was so difficult to put any kind to sue him. So I denounced to Amazon. Amazon, they have a kind of plan of refund money in these kind of issues. I get a refund of some part of that money. I cancel the transaction. Well, and obviously they took measures against that guy. I don't know exactly what kind of measures, but they told me that. in any case, as you can see, normally an error can produce some legal effects. If I didn't do anything, the transaction will be completed and he will receive a computer and can produce well, and the agreement of selling will be valid. But when you discover the error, well, you have quite different consequences. Probably, if there was bad faith, the legal consequence will be that, no? A punishment, no? Some punishment, and also you have to get back the goods if it is possible. If not possible, well, there could be another thing. So, what kind of things we can conclude from this example, the first example, right? That we have to differentiate two kinds of errors. Errors that people commit in good faith and bad faith. In good faith normally produce more legal effects, and if someone is in bad faith, it will produce fewer legal effects. Okay, that's first idea. So you have to differentiate errors that are committed or people have in good faith or bad faith. And second, also that, well, in bad faith you will receive punishment, but when you discover that is the idea. When you discover the error, you should change everything. You should change everything. So this is another easy example. Well, we have two ideas now, no? Distinction, good faith and bad faith. And when you discover the error, everything should change. If this guy falls and break one of his legs, no? He is guilty of that or not? He has a kind of responsibility or not? Ethically, I mean, no? Most of the people will say yes. Why? Because he has no problem with vision, but he himself put something there in his eyes, and that's why he's walking in a very risky way. Quite different is another case now. So is he ignorant or oblivious? I think that you will agree. Oblivious, no? So quite different is this case. If there is another guy walking also, if he goes ahead and he don't touch the rock, he will fall, and probably he can also break his leg. But the second case is quite different. Is the second guy ignorant or oblivious? Probably you will say ignorant, no? What is the difference? Well, the second is blind, a blind guy. It's not his fault if he has some problem walking. You know? He is doing what he can. He put an effort. And that is so important. That is so important to differentiate both cases, because the first one, in the error, is guilty, and the second one, no. Can you see? Now it's not a matter of good faith. It's a matter of negligence. The first one is negligent, and the second one, no. And that is the third idea here, no? If you're negligent, probably you should pay. You're responsible. You have legal liability. That is the third idea. Legal liability. So let's put an example. An example is you give an advice, a legal advice to someone. Are you responsible for that? Well, you can say, no, I'm a student. I'm beginning to know what is the law. So I ignore many things of the law. I was trying to do my best. Yeah. So probably you are not liable. But if you have 40 years, you are 40 years old. You are exercising your profession. You are defending one client in a court, and you forgot to appeal. To appeal, in a case that was so important. You forgot, and was after a month. So, and you realize you cannot say to your client, no, I didn't know that I was able to appeal in your case, so we lost the case. So sorry. No, because you have in that case responsibility. You were negligent. You had to know that because you had to study in your career that you can appeal, and this is the normal thing that people will ask to the professionals. The client can say, I hired you because I understood that you know the law. You were an expert, or you should be an expert, and so on. So you were negligent. Can you see the difference? I think that is more or less clear. Let's put now one examples of these cases. Guilty errors. Guilty errors. There can be many examples. I just will put some of them. Crass and gross misconceptions. Crass and gross misconceptions. So things that normally for the people are so obvious. Think about now once again in the Nazi regime. There were many soldiers that believes but many times unconscious. This one and the general and the other are killing Jews. Hitler, the Führer, told us that we have to do that, and I believe in Hitler. They told that in Nuremberg trials. They told, well, I was obeying the law. Why you are now trialing me? I was obeying the law. I was absolutely convinced that, and I'm still convinced that I have to follow the. What was the answer of Nuremberg? The judge of Nuremberg? Well, they will repeat the same phrase of Gustav Radbruch. You will remember. No law can be unbearably unjust. No law can be unbearably unjust. It's the same. So if things are so evident, so obvious, you cannot say, no, I had a misconception. No, it's that crass misconceptions never produce the law. That is a guilty error, and you should pay for that. That was the answer of Nuremberg, more or less. And that is the answer today in many human rights treaties that says exactly the same. Against this kind of thing, you cannot go. It's not the same, for example, slavery today, second case, than I don't know, 100 years ago, or that 1,000 years ago. 1,000 years ago, people used to born, seeing that there are slaves everywhere. Yeah, probably it's well, it's not so good, and there are many different levels of slavery. So you can see that if you approve at that time, it's not the same that if you approve today. Now we don't have slavery, technically. And if one is promoting that, we will say, no, let's stop. That is, you are guilty because everyone, you didn't born seeing these kind of things. No? So when a misconception is at the beginning, probably that is a guilty misconception. And but if you are in the middle, you're born with that, yeah, we can understand a little more why you are thinking about that. Okay. So you will read everything in the code. In the other cases, it's impossible to cover everything. And there was a funny phrase of Albert Einstein. Two things are infinite: the universe and human stupidity. And I'm not so sure about the universe. So this is Martin Luther King. Nothing in the world is more dangerous than sincere ignorance and conscious stupidity. Yeah. So you can read the whole cases. Let's put at least some case of the second of the contrary example. The excusables. What kind of things we can excuse? Well, there are many things, you know. If everyone in this society agree with something, the most extended common misconceptions, well, we cannot do so much, no? So probably we have to excuse, no? Is everyone thinks, for example, in India, if everyone 100% or 100% believes that there is castes, that if you born in this family, well, you cannot do anything other things that to sweep and to clean the house, but you cannot apply to any other kind of job. And if you are born in this other family, well, you can do a lot of things. And everyone is believing that, well, and from the very beginning of their lives. So it's so common, so extended, that conception, that we will understand a little better what you think about. You believe in that is an error. It is an error. That is against dignity. I think so. I don't know. I think so. At least in my point of view. But I will be able to understand them at least, no? A little more. Why? Because, well, everyone there is believing in that. The slightest or least guilty misconceptions. So when it's just about, for example, in the example of the car I was selling, no? It was a no big issue, but it's a small issue and you can repair it. And I never told you what. This was a little misconception, a little thing that I have to fix in the car that I was selling. Well, you will probably excuse myself in this case. I think so. Normally, yes. And there obviously misconceptions generated by ignorance of the facts that is the case, or formally wrong conceptions that are not unjust. Yeah. For example, if I believe that this was the sacred tree, well, and the community will say no, that was another sacred tree. Well, probably you will excuse me. I don't know, probably no, but conceptions that don't violate the necessary law. Obviously, conceptions against human rights, the necessary reason, natural conceptions probably will not create the law. we are all very ignorant. What happened is that not all ignore the same things. We don't know things about engineer, and they don't know things about the law that we know. That this was the last phrase, so we can finish our lectures on time. So thank you so much for coming.